A bit of breaking news that we can bring you now from the Supreme Court. It's just handed down its judgment in a case brought against Google for collecting web browsing data from iPhone users. Well, our correspondent Ivor Bennett is at the Supreme Court and can tell us more. I mean, this was quite a big case, Ivor.
Yeah, it was seen as a very big case, potentially very legally significant because of the potential repercussions had the court ruled against Google, but in fact they have ruled in favour of Google. That's happened in the last few moments with the ruling read out by Lord Leggett. They have blocked a class action against Google and essentially maintained the status quo on class actions, representative actions, whereby they can only be brought with the opt-in, the express say-so of every potential claimant. I can read you the key line from the ruling now. The Supreme Court unanimously allows the appeal, that refers to the appeal, Google's appeal of a ruling from the Court of Appeal earlier, and restores the order made by the judge, and that refers to the original ruling by the High Court, which ruled in Google's favour. Now, the significance of this case is not the claim itself, but more the way it was brought. The substance of the claim is that Google secretly, illegally tracked the internet activity of millions of iPhone users between 2011 and 2012, regardless of whether or not they had chosen the do not track option on their Safari web browser. But the Supreme Court was not ruling on that. Instead, they are ruling on whether or not the claimant, a man called Richard Lloyd, could bring a case on behalf of everyone who had been affected. So that's estimated to be 4.4 million people in England and Wales. If the court had ruled in his favour, it would have been illegal first, allowing a class action without the opt-in of everyone involved. Normally, class actions can only be brought with the express permission of every single claimant and requiring some sort of proof of fact pertaining to those individuals. But as I say, the court has ruled against him and in favour of Google. It basically means that Google is off the hook for what could have been a very hefty fine indeed. They could have potentially had to pay out up to £750 to everyone involved, millions of users, which could have been a bill looking at £3 billion. But as I say, they're off the hook and the status quo on representative class actions has been maintained.
All right, Ivor, thanks for that.